All right, let's talk estate planning. I have seen some clients recently, new clients come to me, as well as existing clients actually, who have made major mistakes in their estate planning. Major mistakes. And I have to talk about it today because this is an area where mistakes that are made are incredibly costly. Incredibly costly. And let's talk about one of the mistakes I came across this last couple of weeks. I've had two clients, now in their 80s, been with me for, I want to say, 12 years. And I haven't seen them much because they're up in their age and they have some health issues and whatnot, so I haven't seen them much. But we get a phone call from the son of these two parents, and he says, "My mother died a couple of weeks ago." I said, "Sorry to hear that." I said, I'm looking at your mom's IRA account. Your father's the beneficiary, so all we have to do is put her IRA in his name. He goes, "My father died 7 years ago." I go, "What?" "Yeah, he died 7 years ago." I go, "Your mother never notified us that your father died. We've been sending him IRA distribution forms every year for his required minimum distribution, and they're coming back to us signed with his name, and we've been sending him thousands of dollars in required minimum distributions for the last 7 years. And apparently, I guess she was cashing them some way." This is mind-boggling to me because in 37 years in financial services, I never came across a situation like this. Just because we were never notified that somebody died. And we're trying to figure out how to process this now, because he was her beneficiary of her IRA, and he was the beneficiary, and she was the beneficiary of his IRA. Now they're both dead. Who's the beneficiary? Well, obviously it comes down to the estate. My question now is, where was the IRS in all this? The IRS is getting 1099 saying this guy's taking out $6,000 a year from his IRA account and not filing a tax return. I assume she's filing single and not filing joint, but I don't know that for a fact. It's just amazing. We're trying to figure out how to unravel it. How do we get the money to the estate when both of them are dead? Very, very unusual. This is really dropping the ball, okay? And now I sat down with the son on Friday, and we were just shaking our heads, and I told him I didn't even know how to proceed here. We may have to get a lawyer involved in this. Just because we were never notified. Very, very strange situation. Then another problem they had is neither of them had wills. Okay? Neither of them have a will. So he, the son, had to go through a court process to be named an administrator. Now, when you're an administrator of a estate, not an executor, you have the same duties, except you're named by the court instead of named by a will. You have to get insurance that you won't commit fraud against the estate. So you have to get a bond. So we had to do that. Now, it turns out that the deed to the house was in the father's name alone. So there was no right to survivorship for the wife. He had no will. So now this guy has to sell the house as the estate of the father and become administrator of the father's non-will to liquidate the house and go through that process again. Do you see the problems? I'm just illustrating you a major, major problem from people not getting their affairs in order. And that's what this is all about. Getting your affairs in order towards the end of your life. There's no excuse not to have a will. There's no excuse not to change beneficiaries. When your husband dies, you know he's the beneficiary of your account. You have to notify that financial institution and say, I want my children to be the beneficiary. Here's another issue. These IRA accounts total about $128,000. If the kids were the beneficiaries, which they should have been, if the wife notified us, we would have moved the husbands to the wife, we would have changed the beneficiary to the kids. Now the kids, when they inherited that IRA, could delay distributions on it for 10 years. Now, because by default, the estate is the beneficiary, the estate has to pay taxes on a full $128,000 distribution this year. And estate taxes are about double what individual taxes are. I mean, this just gets worse and worse. So the son's sitting in my conference room. I go into my office and I bring up my tax program and I figure out what a $128,000 distribution to an estate would cost. Well, it costs $51,000 in federal taxes and about $7,000 in New Jersey state taxes. So they got to spend $58,000 of the $128,000 on taxes because mom didn't have her affairs in order. Boy, did she screw her kids. Especially the son that has to go through all this administrative crap to try to settle this estate. So you have to be diligent on these things. When things change in your life, you have to change your estate plan. They had no estate plan because they didn't have any wills. How could you be 80-something years old and not have a will? So you got to do these things. And I told the son, he's an adult. I said, well, didn't you bring up anything to them? You know, mom's, after dad died, did you ever look into mom's finances and see what's going on with her? No, she's kind of funny that way. I didn't really want to bring it up. You have to bring it up. You have to be the one to say, Ma, you're not a spring chicken anymore. Dad's gone. Let's see where your assets are, what your wishes are. Let's make sure that your everything for your will is in order. Maybe we should get a power of attorney. Let's make sure everything is as you would want it to be at that. Now that's not a pleasant conversation to have. And when we have that conversation, it's different for every family. Now that conversation should be brought up by the mother or father. And many people do. They call their kids in for a meeting and they say, look, this is what we have. This is my plans when I die. This is how I'm dividing it up, and this is the reasons why. I'm naming Joe as the executor because I think he'd be better at doing it. I'm not trying to slight anybody else. And if you don't know to do all this stuff, that's when you bring in a financial advisor with the family. I meet with entire families at times. My clients, they'll bring in their children, and in my conference room, we'll talk this whole thing out. What will happen if this happens? What will happen if that happens? Maybe some strategies we should employ now. Changes we should make to wills and powers of attorney and things like that. Things we should change in titling. I call this, now if mom and dad don't bring it up to you, then the children have to bring it up to the parents, as uncomfortable as that may be. You have to have that conversation or you're going to step into chaos when they die. And this poor guy, the son, I feel bad for him because he's dealing with a major problem right now because the parents didn't take care of business. I have another new client came in this week, and it's quite sizable estate, quite sizable net worth. Early 70s. He is in somewhat declining health, possibly. She's healthy. And I look at their accounts, which are 7-figure accounts. I mean, pretty big. And I noticed that his wife's name isn't on the joint account on a very large brokerage account. And I asked him, who's this person? He said it's his 31-year-old daughter. I go, why is your 31-year-old daughter the survivor on this sizable amount of the net worth of the family? And he said, well, my wife's not that great with money, and my daughter is pretty good with money, and I figured it'd be best this way. And I said, no, this is terrible. This is not right. I've never seen this before. I said, you can't bypass your own spouse to give a good portion of the estate to your daughter. I mean, that doesn't make a lot of sense for a lot of reasons, because if the daughter's got to give it back to the mother, now you run into estate gift tax issues and stuff like that. She has tax issues on her end. There's all kinds of craziness, but you know, those assets got to be there for the surviving spouse. I mean, as far as surviving spouse, I mean, she's only 71. You know, so again, that was a mistake in estate planning, and you know, and thankfully they understood it as a mistake, and we're reversing it. We're fixing it now. But that's not getting proper advice. That's just doing things because you think, well, this sounds like a good thing to do. And mistakes at the end of your life are very costly. I mentioned all the taxes that the previous person has to pay because they didn't have beneficiaries, and it's got to go through their estate. Maybe it makes sense when you set up, say, an IRA account that you put a contingent beneficiary. If my husband's my beneficiary, if he predeceases me, my 3 children share in this account equally. Now they have the ability to put it in their own IRA account, their inherited IRA account, take it out as they see fit, pay taxes on it as they see fit, and versus it all coming out and going through the estate and being raped in taxes. So, I mean, I come across these things all the time. People make mistakes. They put the house in their kid's name, but the house has been appreciated for 50 years. And now when they die, the kids have to pay capital gains, when if they inherited the house, they wouldn't have to pay capital gains. Just a simple mistake like that. I've seen one where it cost $150,000 because a guy gave his house to his kids 3 months before he died. They would have inherited it tax-free. They would have got a stepped-up cost basis. So kids, if your parents don't come to you, and you know that, especially if there's only one left, it's not as important when you have husband and wife, because when one dies, that's the trigger for really dealing with these issues, because now there's only one survivor left, and when they die, they got to make sure that the family's wealth goes to the kids and everything else. When that happens, you got to initiate that conversation. You got to become the financial caregiver. This is a term I coined this week. Financial caregiver. The person who's going to step in and make sure that mom's affairs are correct. The one that's going to review the will. The one that's going to make sure the accounts are titled properly. Where's all mom's money? Is there a safe deposit box? Does she have cash hidden in the wall somewhere? Make a list of all the assets. Make sure the will's up to date. Make sure there's contingent beneficiaries, and if there's not, that a new will is done. And discuss mom's wishes. Does she have any charities she wants the money to go to? What about her funeral arrangements? All these things need to be discussed. It's an uncomfortable conversation for some families. But if you don't have those conversations and they don't have it with you, many times, many times, there's big mistakes that are incredibly costly. Or even worse, disinheriting your children. Big mistake people make. We see it all the time. Put one child's name on an account for convenience, thinking that your will's going to split it evenly amongst your 3 children, and this sizable account becomes that child's by title, has nothing to do with the will. Legally, it's all theirs. The other kids have been disinherited. That's the most common thing I see all the time. There's no such thing as putting your daughter's name on your account. You're gifting her 50% of it at that point, and she's going to get all of it when you die. You got to know that. And if you don't know that, that's where you got to talk with a financial advisor or somebody in your family who's pretty astute and would understand these things. But estate planning really needs, especially if you have a significant estate, and even if you don't, you really should talk to a financial advisor if you're in the dark about the proper way to deal with these end-of-life issues. Seeing mistakes all the time, and it's really costly, and it's really, it makes me unhappy because it could have been avoided. All right, top of the hour, 732-505-1160 is the call number. My name is Lou Scatigna. Don't go away.